Donald Trump keeps saying he's untouchable. He keeps claiming he has total immunity. He acts like the law no longer applies to him. But the reality is far more complicated. Recently, the Supreme Court ruled that a president cannot be prosecuted for actions that were officially part of his job while in office. That's a massive decision. But here's the part Trump doesn't like. Even his own lawyers admitted in court that not everything alleged in the indictment was an official act. And that's where the real fight begins. Because now the question is, what does the special counsel do next? Prosecutors could narrow the indictment, focus only on unofficial, personal conduct, and try to move forward with the case. But could a trimmed-down case actually go to trial before the election? Probably not, and there are 3 reasons why. First, the judge overseeing the case, Judge Tanya Chutkan, has made it clear that both sides will need time to prepare. This isn't moving fast. Second, Trump appeals everything. Every ruling is challenged. Every delay is exploited. And third, if Trump becomes president again, Department of Justice policy kicks in, a sitting president cannot be prosecuted. Now look at what just happened in New York. Trump was convicted on 34 felony counts for falsifying business records. This was the hush money case involving Stormy Daniels. After the conviction, Trump immediately tried to use the Supreme Court's immunity ruling to get the verdict thrown out. He argued that some evidence came from his time as president, so the entire case should be invalid. The judge said no. Why? Because this wasn't presidential business. It was personal conduct. The judge ruled that the hush money scheme was about protecting Trump's personal reputation in his election campaign, not performing presidential duties. Immunity did not apply. Trump then tried to block sentencing. He appealed. He went all the way to the Supreme Court with an emergency request. Each court said the same thing. No. Trump was sentenced. He received an unconditional discharge. No jail, no probation, no fine. But the conviction stands. Trump is officially a convicted felon, and that matters, because it proves something important. Presidential immunity is not unlimited. Judges are drawing a clear line between official acts and personal crimes. Personal conduct can still be prosecuted. But here's the problem. Trump understands the system's limits. In the federal election interference case, prosecutors had strong evidence. The special counsel even said the evidence was strong enough to win at trial, but Trump won the election. And once he became president again, DOJ policy forced the case to be dismissed. Not because the case was weak, not because immunity protected him, because of policy. So this is where things stand. Judges are pushing back. They are rejecting blanket immunity claims. They are clearing legal paths for prosecutions involving personal conduct. But political power still moves faster than the courts. Trump wants total immunity. Judges keep saying, no, there are limits. And this fight is far from over. The real question is this. When Trump leaves office, will prosecutors revive these cases? Will the political will still exist? Will the evidence still be there? The legal paths are open. The limits have been defined. Now we wait to see whether anyone actually walks those paths. Because this story isn't finished yet.